other facilities in the building. Thank you.
Yeah, thank you, sir. So morning, everyone. I'll give you the boring bit first. So in case of emergency, there are no planned fire drills during this meeting. If you hear a fire alarm, please treat it as a real emergency and evacuate the building via the nearest safe escape route, so through the double doors if that's where it is. The nearest escape route is via the stairs to your left as you leave the council chamber or the public gallery. You exit via the door at the back of the building and walk across the inner car park to the evacuation point, which is the pavement opposite the police station. The lifts can't be used in the event of an emergency, and please do not re-enter the building until you're advised it's safe to do so by a member of staff. In terms of facilities, the gents' toilets are just out through the doors to the right-hand side, and if you carry on through the next set of doors and turn left, the ladies' toilets are there. There is some limited tea and coffee outside on the table, so please do help yourselves to that during breaks. And I think that's it from a housekeeping perspective. Thank you.
Yep, I think that covers everything. Thank you very much. So most people will have met or at least spoken to Louise St. John Howe, the programme officer dealing with the administration of the examination. Louise is completely independent and works for the examination. She's the first point of contact if you have any queries about the procedures for the hearing sessions or the examination generally. You should also contact Louise if you wish to locate any of the documents relevant to the examination, all of which are on the examination website. Louise will be available whilst the hearing sessions are sitting. Otherwise, her contact details, if you do not already have them, are on the examination website. Our role in conducting the examination is to determine whether the submitted island planning strategy satisfies relevant legal and procedural requirements under the 2004 Act and associated regulations, whether the council has complied with the duty to cooperate, and whether the plan is sound. To be sound, the plan must be positively prepared, justified, effective, and consistent with national policy. The starting point for the examination is that the council has submitted what it considers to be a sound plan. There's a set of guidance notes which explain more about the examination. We've identified a number of matters and issues to be explored through these hearings. Our matters and issues have focused on the July to August 2024 representations made on the published submission version of the plan and the evidence produced by the council in support of its plan. The hearing sessions which start today will be based on these matters and issues. The hearing sessions will also reflect on the written statements submitted earlier this month in response to our matters and issues. We will lead the discussions based on hearing agendas we've recently released, and hopefully you should all have been sent a copy of relevant ones. So the plan was submitted for examination on 31st of October 2024. On submission of the plan, the council presented a number of modifications it wishes to make to the plan. These are presented in document CD7. Additionally, through its statements in response to our matters, issues and questions, the council has identified further potential modifications that could be made to the plan. It may well transpire that further main modifications will need to be discussed at these hearing sessions. We ask the council to keep a running schedule of any further changes it proposes, supports, or has no objection to as we go along. We'll also keep a record, and we'll coordinate with the council through Louise, the programme officer, a schedule of modifications. So a programme for the hearing sessions has been produced and now updated with those participating. The hearing sessions will take place over 2 weeks. The hearings this week will look firstly at some of the more strategic aspects of the plan. The second week of the hearings will consider individual policies and proposals. We're mindful that there have been recent changes to the National Planning Policy Framework, the methodology for calculating housing need, and planning policy for traveller sites. Under the transitional arrangements, this examination is looking at consistency with the National Planning Policy against the December 2023 framework, so that's the previous one, and similarly the December 2023 planning policy for traveller sites. The starting point for the examination is that the council submitted at the end of October what it considered to be a sound plan consistent with national policy at that time. Participants attending these hearing sessions will be able to speak. Following the close of the hearing sessions, we'll consider the next steps and will ultimately prepare a report to the council. Morning sessions will normally start at 10 a.m. and afternoon sessions at 2 p.m, although we will be starting earlier on some days as shown on the programme and agendas. The afternoon sessions should be finished by around 5 o'clock, if not beforehand, but may continue marginally past this point if necessary to conclude a discussion. We'll be seeking to accommodate mid-morning and mid-afternoon breaks. We must stress that all participants should be seated and ready to begin the session at the allocated time, and they would return promptly from breaks. The hearing sessions will be relaxed and informal discussions focusing on the particular matters being considered. We'll be asking a series of questions from our agendas and asking the council and others to contribute as appropriate. The emphasis of the examination is whether the submitted plan is sound, and if not, what changes should be made in order for it to be sound. The sound plan cannot be made more sound. Where there are issues of legal compliance, justification, effectiveness and consistency with national policy, we will be considering whether they are repairable. In terms of format, everyone will be given adequate opportunity to speak if they wish to do so. If you wish to speak on any particular issue, please use your nameplates and you should be able to append them. And that will signal to us that you wish to come in on a particular point. We are aware that some participants may not be used to such hearing events. We will ensure that everybody is able to contribute and make their case. We would like to advise everyone to bear in mind that your written representations and statements carry equal weight to what we hear in this room. We would be grateful if all contributions to these hearings are to the point, and in particular identify how the plan should be changed to address a point of soundness or legal compliance. For the benefit of the council and other participants, we would like to advise that we have visited the island and looked at the proposed sites in the submitted plan, the character of the island and some of the proposed settlement gap, local green space and environmental designations. If there is anything raised during these discussions, we'll revisit locations as required, and we anticipate this can be done on an unaccompanied basis. So that concludes our initial announcements. Are there any brief questions on the mechanics of how the hearings will work? No? Okay, thank you. In which case, now the council has the opportunity to make a brief opening statement if it so wishes.
Thank you, Mr. Steen. Yes, I'll just open up with a brief statement from the council. So good morning, everyone. James Brewer, Planning Policy Manager, Isle of Wight Council. On behalf of the Isle of Wight Council, I'd like to formally welcome the planning inspectors, Mr. David Spencer and Mr. Andrew Steen, to the island. And we look forward to taking part in the hearing sessions over the next 2 weeks with all other participants in a positive and respectful manner. We'd also like to thank the inspectors for accommodating some of the logistical restrictions on the timing of sessions, as the council tackles a number of other major issues for the island over the next couple of weeks, including agreement of the budget and key decisions over potential school closures. The council would also like to thank the programme officer, Louise St John Howe, who's provided a high level of professional support to the council and no doubt also to the inspectors since the plan was submitted at the end of October last year. We'd also like to thank everyone who's been part of the plan making process to this point. Planning in general can be inherently complex, it's often emotive, and will consistently result in different viewpoints being held. Shaping a plan over time does require information and input from a wide variety of different places, and the council appreciates everyone who has and continues to give up their time and effort on engaging with this process. This local plan journey started for the planning policy team and the council back in 2016. Since that time, we've seen a change in administration at the council, 5 new versions of the NPPF, a change in government, 2 Regulation 18 consultations, a global pandemic, and numerous macroeconomic circumstances directly affecting the development sector. Each of those milestones provides a different set of challenges for an emerging local plan to consider and absorb, whilst also having to conform with the regulatory framework that the plan has to be prepared under. Planning policy cannot provide the answer for everything or indeed solve every problem, but it can attempt to steer a path through wider uncertainty by providing an up-to-date set of policies that will ultimately provide genuinely plan-led sustainable development. There's no doubt that our island is different to the mainland, and wherever possible, those differences are celebrated and used in a positive way by and within our communities. However, we're also acutely aware that sometimes those differences can create issues and challenges which place the island and our residents at a disadvantage. The corporate plan identifies 3 key areas of action for the island: the provision of affordable housing for island residents, responding to climate change, and enhancing the biosphere and economic recovery. The Council believe that the approaches and suite of policies within the island planning strategy are vital to help address these key areas of action that the island and our community faces, which are also consistent with the 3 pillars of sustainable development. We look forward to exploring some of these topics that the island faces in detail through the next 2 weeks of hearing sessions and demonstrating how we believe the planning policies within the island planning strategy have been written in an island-specific way to try and help address some of those issues and challenges. The Council considers that the IPS is a plan that is capable of being found sound and legally compliant, and invite the inspectors to recommend any modifications that they consider necessary to ensure that will be the case. No plan will ever be seen as a perfect plan by all, but what is essential for the Isle of Wight is to get an island plan in place so that genuinely plan-led sustainable development can come forward. Thank you.
Thank you.
Thank you. Well, good morning, everybody. Just to introduce myself, I'm David Spencer, as Mr. Steen's introduced, one of the 2 inspectors, and I'm here to, you're going to probably hear a lot from me this week as I'm dealing with matters 1, 2, 3, 8, basically this week. Hopefully you'll get used to me over the next 3 days. The first session we're going to deal with this morning is matter 1. I'm not going to go through a formal introduction, as obviously Mr. Steen has done that. I think we've got 1 participant for this session, that's Councillor Jarman. We're anticipating somebody from the RSPB, but I don't think they've come this morning. So a lot of my questions are going to be directed to the Council in the first instance, but I will bring you in, Councillor Jarman, on relevant points. I think it's been indicated we will need to use the microphones, and I think they're on a 1 use. 1 can only be on at any one time. So once you've made your contribution, you will need to switch your microphones off. But you're probably familiar with that, Councillor Jarman, from probably many meetings in this room. So I'm going to work through some of the questions on the agenda. So for those of you who are here for matter 2, you'll have to patiently observe while we have this discussion, but we will be on to matter 2 later this morning. So if I can turn, I think, to the Council in the first instance, so this is a session on sort of plan making in general, legal compliance, and for a lot of plan examinations, one of the main issues for legal compliance is around the duty to cooperate. We'll come on to that shortly. And I think I'm looking to Mr. Brewer in the first instance to assist on most points, and obviously you can bring in your team where necessary. But in terms of the first questions that we identified was around compliance with the local development scheme, the programme for plan making. You've confirmed in response to our questions that has been done in accordance. We've got a fairly up-to-date local development scheme from last year, but a slight new question just to kind of put some thoughts in our mind at ease is that obviously alongside the changes to the National Planning Policy Framework that Mr. Steen's outlined. I appreciate you're not being examined under the latest NPPF, but it does, alongside that, the government saw all local planning authorities to produce an updated local development scheme within 12 weeks of the publication of the NPPF, which I think will take us to some point next week. I don't know if the Council can just briefly update us whether that's something you are undertaking and whether we're assuming it would have no ramifications for the milestones, the island planning strategy, but you may tell us otherwise, Mr. Brewer.
Thank you, Mr. Spencer. So yeah, the short answer is yes. The Council will be looking to publish a new local development scheme by the 6th of March. You're correct, it won't affect the dates for the IPS and the milestones we've got within it. So we're still projected with a potential adoption date of October, November this year, subject to obviously the process and the progress of the hearing sessions. However, yeah, the new LDS will be trying to trying to look ahead and take account of potentially what might happen post IPS, although that's slightly challenging at the moment because obviously we're still waiting for the details from the Planning and Infrastructure Bill, which is due to be published in the spring. So obviously within that, we're expecting some changes to the plan making system. And so we'll give our best guess as much as we can do in that revised LDS about post IPS milestones. But certainly we're aware of the transition arrangements in the NPPF and what that means for us as a council as well, certainly when it comes to housing requirement, and that triggers our expectation for us to start work on a new plan straight away. So yeah, we'll be doing that.
Thank you. And is that a document you have to get kind of member approval, or do you have officer delegation around the updated scheme?
We have officer delegation for the local development scheme, although we will run it through the portfolio holder.
And perhaps just a brief action for the council when that local development scheme is updated. Can that be submitted in as an examination document for us to have?
Absolutely fine. Yeah, not a problem at all. Yeah.
I'm just thinking as a technicality, our report has to kind of conclude and whether it's in terms of also through the examination process, we've met, it's been consistent with the latest local development scheme. So if there's a change, we'll need to have a look to it. Thank you. We then subsequently asked around clarity on obviously SAVE policies. The council has a 2012 core strategy, is that correct? And yes. I think our understanding is the island planning strategy will effectively supersede all of the policies in the core strategy, Bath, mineral, those relating to minerals and waste. Is that correct? That's set out at Appendix 6 of the plan. Yeah. And then we asked a further question around just on sort of plan making in general around equalities. Obviously, as inspectors, we're bound by Section 149 of the Equality Act. I think the council, in response to our question, said that there had been an accompanying equalities impact assessment as part of the report process when you took the planning strategy through full council, but there's not a separate, what we would perhaps anticipate or see as a separately published equalities impact assessment report. It wasn't clear from the council's response to our question whether that's something you were intending to do, were the plan to get to a main modification stage.
Thank you. Yes, so there's a couple of points to raise on that. So you're correct that the full council report, when the IPS went to full council in May last year, it was accompanied by an equalities impact assessment. Should the IPS go back to full council for a decision to adopt, it would also be accompanied by an equalities impact assessment at that time. However, we can produce one as part of any main modifications as well. Obviously aware that main mods process would need other pieces of work alongside it, such as SA, HRA effectively, so we can do that as part of that process as well.
Thank you. I mean, I think a suggestion at this early stage of the examination process is, I think, rather than just solely I appreciate you have to do it as part of the reporting process, but I think our advice would be to publish or prepare a separate equalities impact assessment statement. It doesn't need to be a particularly long or onerous document. There are obviously examples out there. As you say, Mr. Brewer, subject to getting sort of main modifications, there would be updates to various other documents, and that could sit alongside that process. Will obviously come on to things like policy H11, gypsies and travellers, and the issue has been raised in the representations there. So I think it is something we need to cover. Thank you. I've got no further questions on equalities. So I'm going to move on to public consultation. Just very briefly on this, we obviously raised questions as part of, we obviously looked at this as part of the MIQs. There seems to us to be a number of representations, I think particularly in relation to the freshwater or west of Wight area around the adequacy of the public consultation that had been undertaken on the proposed submission plan. whether it met the requirements, whether people's ability to comment on the plan had been compromised, and in particular there seemed to be a particular issue around the consultation forms and the degree to which they were changed, or there was an alteration at a relatively late stage of the consultation process. Appreciate the council's comprehensively answered this in its matter one statement. I will bring in Councillor Jarman shortly, but I'll maybe give you, Mr. Brewer, in the first instance, to kind of perhaps provide some illumination on, from the outsiders, people who weren't involved in that process, what the potential issue was and why we should arrive at a conclusion that consultation has been adequate and there's been no sort of undue ability to provide comments at the appropriate time.
Yeah, thank you, Mr. Spencer. So yeah, as you state, our kind of answers to MIQs 1.4, 1.5 set out in the detailed response. I guess, however, just to kind of to add to that a little bit, I suppose our stance is very much that there wasn't anyone prejudiced through that process. So the 6-week period was well advertised. There was a press release. There were a number of press articles about it. The information was available on the council website for the duration of the 6-week period. So in terms of the if you like, the communication and the publication of the fact that the Reg 19 process was taking place, we're comfortable that we did everything we needed to do to advertise that. In response to the particular point about the form, yes, there was an error on one of the online comment forms, and it's related to one of the answers that was in the form. The question itself didn't change, which was question 4. That was corrected. However, as we set out in our statement, no reps were rejected on that basis. Everyone answered the same question. So we're comfortable that in terms of the responses that we got in, that everything is in order. It goes without saying that the questions are, at this stage of the formal plan making process, they can be quite complex. We are asking people which bit of the plan they're referring to, why they think it's lead compliant or potentially not consistent with the NPPF. So understandably, that can be quite confusing for people who aren't operating in the planning environment. So we did again have offices available throughout that period. Should people have queries, we're available to contact. We put on a couple of sessions during a couple of afternoons, but obviously we're always available on email should people have queries or questions during that process. There were some that were raised during that came into our email address, and we responded to them. So again, there was activity in terms of people coming to us and saying we're not quite sure. We were able to provide a response. So from the council's perspective, we're comfortable that we did everything we could do to assist people in what is a complex and difficult part of the plan making process.
Thank you.
So before Councillor Jarman comments, so could I just add, without trying to make this into a legal exercise, because clearly plan examination shouldn't be overly legalistic, but it is just worth making the point that there is not a prescribed form for making representations. There is, from the planning inspectorate, a model form which is recommended for use, but the guidance notes with that make it absolutely clear that it's a model form, not a prescribed form that you're required to use. And so with all of these things, the question is to look at the substance rather than the technicalities, and asking yourself, looking at the substance, does the form that was provided give people a fair opportunity to make representations on the issues that are relevant to an examination? What we would say, based on obviously what we said in the hearing statement, clearly the questions that we used, which were taken from the model form, did not change at any stage in the process. What did change was, as it were, the supplementary notes underneath the questions, which were an attempt to helpfully, as it were, paraphrase the sort of things that people might need to think about when answering the questions. But strictly, that's, as it were, superfluous information, because they're as capable of reading guidance and the legal framework as anybody else. So whilst it's right, as we've identified, that we did update it partway through the examination, that doesn't go to as any kind of legal requirement. That just provides, as it were, clarity and further information. And in a sense, the proof of the pudding, if I can use that non-legal term, is in the output. That's to say, you clearly have been given a large number of representations from people who successfully responded to the invitation. And there can't really be any realistic sense in which those persons have been prejudiced in what they've been able to tell you about what they think is deficient with the plan or needs to be addressed. So we would say that you can be confident, as Mr. Brewer has indicated, that there are no deficiencies of, as it were, legal note that would hinder you in concluding that there has been satisfactory compliance.
Thank you for that. So, Councillor Jarman, obviously I've read your representations on the plan. I think you take a different view in terms of the approach that was taken to consultation on the proposed submission plan back in, I think it was July, August of last year.
Yes, so first of all, let me add the welcome on behalf of the councillors. There's a couple of us here in the hall today to our glorious Isle of Wight. I hope you enjoy your visit. Yes, I take a very different view, and I'm grateful to Mr. Bedford for interjecting there ahead of me talking with to amplify their views, I'm sure, from the officer side. The views that I will express are not only mine, they are the collated views of a very large number of residents in my area, and indeed of the parish councils that I sit on, which is both Totland and Freshwater parish councils. So the situation that we were faced with, I understand the minimalisation that's been put in the response to you from Isle of Wight Council to those issues were judged by the residents and by the parish council to be quite significant. Now, I understand that planning officers and Mr. Bedford, as a KC specialist in planning, may feel that issues are quite minor, but the issues that are being addressed here by residents are remarkably complex, and it takes them some time to absorb those issues and to understand them. So the nature of the forum may have seemed to some relatively simple and the explanatory notes adequate. To many others, that they didn't. And if I was to summarize the issues that we were faced with, sorry about that, it's a persistent problem here, only recently. I think they fall just about a sentence under each of 10 complexities we found. The first one was that because of the length of time in getting to that R19, the documentation itself had changed substantially along that route. And indeed, from the last version of R18 that went out to the R19 submission, there were really quite monumental changes to many of the elements of it. And those were so substantial that many believed that going directly to R19 would not be an appropriate measure, and that people needed to be able to go step back a little bit to look at the depth of those changes and to be able to respond to those changes individually to the council in that instance, which is what R18 would have been enabled them to do. They had not received any individual feedback, including to the parish, town and community councils on their submissions. So Freshwater Parish Council, for example, had been waiting for replies to the quite significant issues that it had raised. Most of those related to the fact that the R19 proposed version did not recognise the neighbourhood plans. And we were always told that neighbourhood plans took a high degree of weight within the process. So an example of that would be that within the Freshwater neighbourhood plan, the desire was very much to retain the development boundary as it was. That representation had been made very strongly. It was ignored, and the development boundary extended to adjacent sites, which is very much what the parish council did not want. They wanted to maintain those sites as separations between communities, which are quite distinct in many ways. And although the boundary between sometimes one small hamlet and another might only be one remaining field, that distinction remains important. Otherwise, we have a conglomeration of areas. And I know that that's something which is reflected in national policy as well as being undesirable. So that was the first key point. The second point was that as well as not getting any feedback on their comments, and the next one being substantially different, they had expected there to be a proper degree of dialogue within the local parish council, and they found that to be very limited and very late within the process. The third issue that was raised repeatedly by the local community was that the consultation was scheduled entirely within school summer holidays. Now, I know these things are sometimes accidental, and not everybody has school children these days. I don't, mine are long grown up, although I have grandchildren, I'm aware of when the holidays are. But to schedule the consultation entirely within the summer holidays was problematic in its own right, and it ran from the 8th of July through to the middle of August. The 19th of August it finished, and there were many representations that it should have gone outside of term time to allow parents and others to more fully engage in the process. You've heard a number of things about the consultation being online, and the fourth issue that I would like to amplify a little bit is the fact that the main consultation page of the Isle of Wight Council did not list this consultation for the first 11 days of that 6-week period. Now, I understand that some would say it's only 11 days, but we only have 6 weeks. And for it not to be there for the first 11 days clearly impeded its process. So if I was to say, was it online and available for people for a continuous 6-week period, I would have to say it may have been if you knew where to look and where to go directly in to find it, but not if you simply went to the consultation page several times during that initial period, looking for it, waiting to reply and not finding it. The fifth element I would raise, which came up in your earlier introduction about accessibility, was the fact that there were very few public consultation slots. And the slots that there were all at the council offices. They were a couple of hours long. And many of the residents who live in the West Wight in particular, and I suspect in other rural areas, would have found the idea of getting on a bus in Topland and coming to Newport and changing and getting on a bus heading out to Ryde, and then a fairly lengthy walk down to the planning offices for one of those 2-hour sessions was well beyond them. We would very much have appreciated local engagement, and local is a strange word, sometimes applied to the island, but on the island, we would have regarded local as being in freshwater. Okay, it's only an hour on a bus from where we are at the moment, but that hour for people with limited mobility can be a significant issue. The sixth one, just being very quick with them, related to the questions. And I know that you've had representation made that those errors that were pointed out on question 5 and 4 in particular were rectified, but they were only rectified 3 days before the end of the consultation period. Now, what does that mean? It means that some people will have responded to those questions in the first majority part. Others would have replied in the last period. Some attempted to reply a second time because they didn't know when there was a change, because we announced there's been a change at the last minute, what they should do. There was a great deal of confusion caused about that. That leads to some inconsistency within the consultation period itself. And we were not happy about that inconsistency of replies or the confusion that it caused. We were aware that legal issues have been raised, particularly by Freshwater Parish Council, and the answers to those legal issues were received at the Freshwater Parish Council on the 15th of August. So that's just a couple of working days before the end of the consultation period. And during the summer period, most parish, town and community councils do not have meetings in the summer, particularly during the summer holidays. And so the opportunity for parish, town and community councils to respond at very short notice with a couple of days during the school holiday when they do not normally have meetings was again unsatisfactory. It should have overlapped at least with the September period when most of those parish councils would have come back into sitting. You've heard about the complexity of the document. We did, as a parish council, actually run some of the notes through one of the online little engines there, which gives you a readability index for it, which was quoted in one of the full council meetings. And certainly the language was satisfactory to somebody of a first degree at a university course. Now, whilst that might be acceptable to some, I think for most of the residents on the island, that is an unrealistic expectation. And there should be a way of explaining in a relatively simple form what is being asked of them and what the consequences of that would be. And that was clearly not the case. So what we had to do was to arrange local forums with councillors and some parish staff and local residents groups, and to invite any residents who had not been able to understand the material to come along. The first one of those we held was at the Sports Centre in Freshwater. Unfortunately, only 20 minutes into the session, the website went down again. It had previously been down during the consultation period for a weekend for scheduled maintenance, and we had a problem accessing it. We then had to take paper documents, get everybody to sign that they would allow that to be done later by councillors, and a group of councillors and residents spent 2 complete nights filing those on behalf of residents, simply because the residents were incapable of using that online mechanism. We were told that documents would be available at the library, and none were found. So when I come on to the engagement process, and one of the issues here is procedural, do I believe that any one of those would be sufficient to invalidate the process? And I would probably say no. But collectively, when I look at those 10 issues that I've got on my list and the number of impediments that were in front of residents in terms of comprehension and access and accessibility, and in terms of the document being changed very late in the process, and of parish councils being largely not sitting and unable to support residents, I would say that is in combination such that questions, if not questioning the very validity of that process, would be a real consideration. And I'll leave those thoughts with you. Thank you.
Thank you, Councillor Jarman. And obviously we have raised the question. We've obviously read the representations that have been kind of duly made. Those that were sort of questionable whether they were in time, I think we've taken a generous view and included a number of further representations that we're on the sort of the cusp or the margin of time. So we're obviously aware of the issues that are before us. Thank you for that. If I can just turn to the council then in response to some of those points. Obviously, I think we all recognise and appreciate plan making is a complex kind of process. It does have its own language, and apologies, we're probably going to slip into quite a bit of that language during the next sort of 2 weeks. But in terms of what is required of the council and the thresholds that you need to comply with, one is obviously in accordance with your statement of community involvement, whether you kind of met what you set out there, and then also in terms of the regulations. Now, I appreciate the Town and Country Planning Local Plan Regulations 2012 are relatively broad in what they say. There's very little prescription in terms of meeting that kind of legal requirements. But in terms of Mr. Brewer, in terms of what the council set out for itself to do through the statement of community involvement, did you meet those requirements? Should we be in particular concerned about the timing of the Regulation 19 consultation and kind of overlap with school holidays, people's availability or ability to participate at that time of year?
Thank you, Mr. Spencer, and thank you, Councillor Jarman, for setting out your points in a very logical way that's easy to understand. So I appreciate that. Thank you. A couple of points just to perhaps just note in terms of, I know there was mention of the website and being available on the consultation page. So just for clarity, The IPS has its own dedicated web page, and all of the consultation, the materials available on that from the start on Monday the 8th, and it then did appear on the other consultation page on the website by Friday the 12th of July, so we can provide the necessary screenshots of that if necessary. I guess in terms of the timing of the period of representation, I guess the council was kind of probably never going to be able to win on that point, because if we did it outside the school holidays, people are then at work. So it's a difficult one sometimes to pitch, but obviously we've got lots of things to consider when we're looking at when we're going to run that period of representation. We were originally meant to go out a bit earlier than that, but then someone called a general election, so that delayed us, which we couldn't go out during that period. The full council decision originally having been in May to publish for Reg 19. Obviously, the first part of that period was outside the summer holidays, because they didn't start till the kind of middle end of July, and the third week of July, I think. So there was a period at the front end which was outside. So from our perspective, we've met everything that we've set out in the SCI, and we've got documents in the document library that set those out. So GS 21, 22 and 23 set out the compliance with the SCI at each stage. And yeah, in terms of the consultation statement itself, it's probably just again worth noting that during that Reg 19 period of representation, we had 730 responses from 108 respondents. So there was a number of people who were able to access and get through that process. Totally accept, as you set out, Mr. Spencer, and as Councillor Jarman set out, the language is not easy sometimes, and it is a bit of a minefield sometimes to pick your way through it. But fundamentally, from our perspective, we're comfortable that everything we did was in conformity with the SCI and the regs, where specific as they can be.
So can I just add, by way of sort of comment on some of those points, again trying to keep it brief. Firstly, as a matter of fact, and obviously if you want information on this we can provide it, but we think that the school holidays in 2024, the school holiday period actually began on the 29th of July. So that's relevant to the point about whether there was a period of overlap between term time and non-term time. But secondly, and this is again, I'm afraid, the slightly more legalistic point, as you will be well aware, in terms of the plan making stages, there is the thing called Regulation 18 and the thing called Regulation 19. Regulation 18 is intended to be a consultation. That's to say, the person who's producing the plan produces information about what a plan with the subject matter of the intended plan should contain, and asks for views on that. And that's a very broad canvas, but many councils, including this one, do use Regulation 18 to produce effectively a draft version of a plan, which goes beyond, in terms of its detail, what actually the regulations require you to do, but they do produce a draft plan which they consult on. And the purpose of consultation is clearly to invite views, to allow the council to be informed of those views before it moves to the proposed plan at the Regulation 19 stage. That Regulation 19 is very different. Although it is not uncommon that some people refer to Regulation 19 as a consultation, strictly it is not a consultation. What it is an opportunity, once the council has produced the final version of the plan it intends to submit, for other people to make representations on the content of that plan, but not in order to persuade the council. The purpose of those representations is to inform the planning inspectorate who are examining the plan as to whether or not the plan meets the legal requirements and is or isn't sound. And without getting too bogged down in the history of the legislation, there was a significant change when the 2004 Act was introduced, and when the 2012 regulations were introduced, in order to try to abridge the time process, the view was that rather than representations be only made once a plan had been submitted, so they all came straight to the planning inspectorate, the view was that the representation should come into the council before the plan was submitted and then be submitted to the inspectorate. But it wasn't because the intention was that the council was then supposed to respond to each one of those representations. That's not part of the 2012 regime. All that they're expected to do, which obviously we did do with one of the core documents, is produce a summary of the issues, the main issues raised in those representations. So the misconception that there is actually a dialogue at the Regulation 19 stage between the plan making body and the representees is, I'm afraid, a misconception. It's one of those things that I say the structure of the Act and the regulations don't provide for. What they provide for is the opportunity for people to make their representations at Regulation 19, which Councillor Jarman and various other interest groups in and around Freshwater and Topland have clearly done so, in order to inform you, sirs, the examining inspectors, of what they see as the problems with the plan. And obviously you can then examine all of those problems to the extent that you think they go to any of the issues which are part of the examination. So in summary, I would simply say that the fact that this plan, the IPS as submitted, may be different to the Regulation 18 versions is, with respect, not an issue that goes anywhere, because this plan isn't intended to engage in a dialogue with affected persons. And so far as the opportunity to make representations, that was clearly provided. And the requirements were satisfied, and we think therefore that nobody has been prejudiced, because anybody who made a representation, and as you've indicated, so you've already exercised the discretion to allow some who might have been on the cusp of being outside the time frame to include their representations. Anybody who made a representation is now completely free to participate in this examination and explain to you exactly what it is that they consider are the problems with the plan as formulated by the council. Thank you, sir.
Thank you. Obviously, you've got your points, Councillor Jarman, in terms of your individual points that you've raised to us based on your representation, your view that cumulatively that kind of gets us to a point where I think you're inviting us to look at whether the kind of the procedural kind of requirements have been met. Obviously, the council's given their response. I appreciate we're going to, as the examination hearings carry on, we're going to look at some of the individual areas of concern. But if you felt this morning that presented to us what you think are the kind of key considerations we need to have in our minds and our thought process in terms of, you know, procedurally, the plan preparation has met requirements around consultation.
Yes, and again, I'm obliged to Mr. Boer and Mr. Bedford for their replies. They do exemplify very clearly, in my mind, the differential between a legal perspective on a consultation, which was described as a consultation in both cases, and the way that that is received. And I think we're all aware through our training in life, and perhaps professional as well, that communication is a two-way street. And we should be very mindful that we are not dealing with people with a first year university qualification as an average. We are dealing with regular people on the Isle of Wight, a particularly aged population, I have to say, and I think you're well over the demographics, they'll come out later on this. And in dealing with those, one should be extraordinarily mindful of the engagement process with them. So yes, I understand that some of the schools didn't break up until the end of July, but the reality, as we all know, is that when examinations are finished at the end of June and beginning of July, many students finish at that point anyway and go off on holiday with their parents. Mine certainly did when I was younger. Some of the primary schools continue a little bit longer, I agree. But in July and August, those community councils at the parish level are not there to engage with people, to support with people, to put notices on notice board, to hold meetings. You know, they are in recess, and that is a big problem that occurred on this, that people were uninformed, unable to get any sort of address at all, and it did become a little bit of a panic. And certainly for changes only to come out 2 or 3 days before the end of the consultation period, left the parish council in a huge difficulty. The requirement there is that they must publish agendas for meetings, for example, 7 days in advance. Well, there's no point in them being able to publish 7 days in advance when there's only 3 days of a consultation process left. So, you know, difficulties all around, I think, is the issue. And this could have been very much better planned. And I think a lot of people were significantly disadvantaged by it. The confusion with the previous one, I understand what Mr. Bedford said about his clarification of various acts which have come in during that process. It may be that there are a few percentage of people who would be able to follow that degree of legal argument around us. I think the majority of people again would not, and would therefore be again disadvantaged by a lack of that clarity. Certainly, people saw what was described as Regulation 18 as a consultation on the dips. It was portrayed in that way, it was presented in that way at every opportunity. So they saw that as a consultation on a version of a document. That document was substantially changed. There was no reply to them. Many of them did expect a reply, I have to say, particularly at the parish council level, and they didn't get it. So when the very changed Regulation 19 version came out, again, more confusion abounded. One of the common questions we were presented with was, well, I've already commented on the dips. I don't have to reply again, do I? Well, you're not really replying, you're making a representation. And of course, that differential is lost on most people. They cannot follow that distinction. It's too subtle. They see it as a council issued document, a council issued consultation, a council issued reply through a council website. They do not see it as addressing planning inspectors in the way that we might sit here very nicely and politely and engage with ourselves in that understanding. So again, the presentation of this material to the general public should have been much better prepared. And those consultation sessions should have been on a local basis to enable people, you know, with limited means, limited mobility, other accessibility issues to engage in the process. So yes, I suspect the representation you've probably read is disproportionate for the West Wight, not because the West Wight people felt more passionately about this, but because the local councillors and the local residents group made an enormous effort to go out and do the local engagement that the Isle of Wight Council should have been doing. The fact that that did not occur elsewhere on the island shouldn't be taken as a good response to the representation. It should be shown as just how awful the representation was, because had a similar effort been provided around the whole island, you might have got several thousand replies, not the ones that were disproportionately represented by the West Wight.
Give you the final it's your plan, so give you the final opportunity. If there's anything you want to pick up in Councillor Jarman's rebuttal.
Excuse me. No, we're happy with, obviously we've put in the hearing statements and the verbal submission we've given today. And just, I guess, one point of clarity that I will add is that obviously during the Regulation 18 consultations, the council was very active. It visited all the town and parish community councils that wanted a meeting. We did dedicated roadshow sessions. So during that consultation process, we were very active and did reach out to all those town, parish and community councils that wanted it.
Thank you. We'll come back to, through the various sessions, undoubtedly some of the kind of the history to some of the things in terms of how sites kind of came forward or how particular settlements have been dealt with as part of the spatial strategy. So we'll come back to it. So thank you for that, Councillor Jarman. I'm going to move on with the agenda. So the next area I just wanted to cover relatively briefly is around the duty to cooperate. It's still with us, so we're still bound by the legal requirements. And to some extent, obviously the council's prepared a duty to cooperate statements. You've identified the kind of the various mechanisms you've used to engage with those nearest to you. You've got signed statements of common ground. I mean, in terms of the kind of the issues that have been identified, I mean, it seems to us that there's a strong degree of consensus amongst certainly at the local authority level that the Isle of Wight is its own housing market area. There is an issue around separation created by the Solent to the extent that it limits the practicalities of either the Isle of Wight's unmet needs being accommodated on the nearest parts of the mainland and vice versa. Any unmet needs from Portsmouth, Southampton, New Forest signalling they might have issues, but they're not saying the Isle of Wight is a obvious candidate to be taking their unmet needs. The issue, as I say, seems to be around the kind of the degree of separation and the cost of effectively getting to and from the island. For those of us, and include myself here, are not familiar with that, I mean, is that a significant barrier that kind of genuinely creates strong self-containment within the island and will significantly limit from either an economic or social kind of factors, people living, commuting from the island to the mainland and vice versa?
Thank you. So yes, I think the short answer again is yes. The Solent does provide a barrier. It's also opportunity in some ways as well. But certainly when we're thinking around that transition of people and looking at kind of housing need across the different authorities, it's probably worth just starting around the reason why we sought statements of common ground with the authorities that we did do. So Portsmouth, Southampton, New Forest and New Forest National Park, and that is predominantly because they are the authorities where the ferry connections effectively are from the island to the mainland. So if you're thinking of the most practical places where you could possibly consider this to be an issue in terms of that potential looking at unmet need, then those would be the ones to do that. But then you do come down to a key issue of cost, and I'm sure everyone in the room is well aware of the costs of getting across the Solent. So if you're having to do that for work every day, that is a particular barrier, certainly for many levels of employment, and also the logistics of it as well. The ferries is a conversation we could probably spend 2 weeks on, the ins and outs of the ferries and the disadvantages and advantages, but they are a limiting factor. So yeah, you're absolutely correct that there is consensus around the authorities over that. And I think also it's worth just flagging some of the work we did through our housing needs assessment in 2022 that looked at the postcodes and also the ability of and where those house moves take place. And the island is really self-contained when compared to other authorities that obviously will share land borders with neighbouring planning authorities. So yeah, that there is the consensus, and we're comfortable that it's not a practical solution for our unmet need to go to the mainland, and equally some of the mainland authorities' unmet need to be taken over here.
Thank you. I didn't have other people indicated on my agenda as Mr. Brewer's indicated. As soon as he mentioned a particular theme, it's probably people want to talk about it for at some depth. We may be able to bring in your related point as part of some of the other discussions. I do appreciate. I mean, I think whether this goes to the points, is it Mr. Long, Mr. Salmon, maybe indicate. I mean, as I say, I mean, there seems to be certainly from a local authority perspective, a consensus around separation does limit the ability to kind of meet corresponding unmet needs. I think in the regulation 19 representations, I think picked up a flavour that Ryde may be an area because of the connectivity to Portsmouth where the barrier is weakest, and therefore Ryde could be a location that could meet some unmet need if that's the case from Portsmouth in particular. obviously that's not a view particularly shared by Portsmouth City Council, but is there any kind of grist to that mill of Ryde is potentially a sustainable location for unmet needs from Portsmouth?
So before Mr. Brewer sort of provides an answer on that, I think it is quite important to keep in mind the point that this element of the agenda is directly on the duty to cooperate and not on wider issues about the island's housing needs and what's an appropriate strategy for dealing with those, which clearly both Mr. Salmon and Mr. Long have got views on, but those are separate topics. And in the context of the duty to cooperate, it obviously applies to particular parties. That's the ones that are set out in the 2012 regulations. And those are the parties with whom the council has engaged. And it's also worth making the point that the duty to cooperate only applies to those plan-making matters which relate to what are said to be significant matters. And then there's this very prescriptive definition of a significant matter in the legislation, that a significant matter is something concerned with the sustainable development or use of land which has or would have a significant impact on at least two planning areas. And so in a sense, almost it's not enough to say, well, there could be impacts in, let's say, Portsmouth, unless there are also impacts in another area. You have to have both sides of the equation in order for it to actually fall within the umbrella of the duty to cooperate. And there is simply no evidence of that, and there's certainly no evidence supported by our engagement with the duty to cooperate partners that would suggest that there's anything in relation to the housing provision issue that could be said to give rise to a duty to cooperate. I say that not in a sense wanting to open up or to get into the wider issues, which you rightly say we will get onto, but it is, I say, quite important to be clear about that this agenda item is dealing with the duty to cooperate, and whether there is any basis for anybody in terms of the representations to say there's been non-compliance. And clearly we would suggest that clearly is not any factual or legal basis for that. But then, sorry, going back to your question, which was put directly to Mr. Brewer, as to whether relationships between the mainland and the island, whether Ryde, as it were, sits in a different category to any of the other settlements.
And I think that the short answer is, whilst logically you might think that's the case, we would maintain the position that it doesn't. Whilst there is the proximity and there is that direct ferry connection, you still have to get on the ferry, you still have to pay for it. That is a quite considerable sum of money if you're having to do that every day. And again, that's, I think, picked up in our answer to MIQ 1.9. Certainly around that potential 1.8, sorry, around that potential financial burden that you would then be placing on that if you were looking to explore that in further detail. But I think we'll rely on everything we've got in our hearing statements and the statements of common ground.
Thank you. And then as a subsequent duty to cooperate issue, and as I say, we've obviously seen the respective statements of common ground with the nearest mainland authorities on kind of unmet needs. Another, it seems to us, kind of key strategic matter is around the environment and protection of the environment in relation to obviously various national components of the national sites network, in terms of special areas of conservation, special protection areas, and Ramsar sites. And the two main cross-boundary issues from our reading appear to be the recreational pressures on the solent and nutrient neutrality. We just very quickly deal with recreational pressures. Would we be correct in saying that there is a mitigation kind of framework to that, and all the respective authorities have kind of signed up to that, and that's how that will kind of work on a cross-boundary basis?
Yes, you're absolutely correct. So we have the bird aware strategy, which is a Solent-wide mitigation strategy that effectively developers pay a sum of money per new dwelling, which then goes into the bird aware project, and that funds rangers and work around the whole of the coast, both on the mainland and the island, to address that issue of recreational disturbance.
Does the Isle of so the Isle of Wight will be collecting funds potentially through what Section 106 or a natural undertaking, and then do you administer it, or does a host or another authority take on that sort of administrative role?
Thankfully, we don't administer the bird aware projects ourselves. There is a separate project team for that, but yes, we collect those contributions through a planning obligation for every new house that sits within the buffer zone that's identified as part of that mitigation strategy, and it's the same for the mainland. So the contributions are the same both on the mainland and on the island.
And then the other strand of the environmental kind of key strategic issue raised there was the nutrient neutrality. Would it be correct to conclude that there's now an agreed approach around nitrate credits? I was just wanting to understand from reading the material whether the Isle of Wight has a particular role in terms of potential strategic opportunities on the island that through cross-boundary matters can help development elsewhere within the wider sort of Solent area.
Yeah, so I guess in a nutshell, the nutrient neutrality issue is less of an issue for development coming forward on the island, because the majority of our development connects and goes out through the Sandown wastewater treatment works, which doesn't go into the designated sites. However, we do have a number of kind of strategic nitrate credit mitigation sites on the island, and for reasons that only Natural England can explain, you can potentially develop a house on the mainland and buy nitrate credit on the island to offset that mitigation, that harm. So yes, the island plays a role in that. There are three sites already set up on that basis, and I suspect there will be more, certainly with the advent of BNG as well, and the fact that you can stack those sites. But I'm sure we'll come on to that probably next week when we talk about the environment policies in more detail.
Thank you. And then finally, on the duty to cooperate, you obviously entered into a statement of common ground with New Forest District Council. Was signed post submission of the plan in the early part of November at document ED7. Should we be concerned about the timing of that? Was that an administrative, just the logistics of getting signatures?
It was entirely down to the internal sign-off process at New Forest District Council. So we did the same thing with all the authorities in terms of the draft statements, and we're aiming to get them all signed off pre-submission. But unfortunately, their internal sign-off process was slightly longer. But that was the only reason, hence why it then got submitted relatively swiftly after the plan had been submitted.
So I think just if that were something that you were thinking about, it's probably fair to add the draft statement of common ground existed as a document at the point that the council was ready to submit its plan. It simply, as Mr. Brewer has explained, it hadn't, because of New Forest's admin, been able to reach a signed document. So it wasn't that, in a sense, this was a point that was forgotten about. It was there in the system. It was just that, I say, they hadn't managed to achieve sign off of the document, albeit, I say, the discussions had gone off through, there were no duty to cooperate issues arising from those discussions, but procedurally it wasn't possible to have it in place at the time of the submission.
Thank you. That's all I've got on duty to cooperate. We will have a mid-morning adjournment shortly, but I'm just going to make some headway into habitat regs before we, sorry, habitat regulations before we. I'm going to have to try and recall your specific, you're not down, well, you're obviously here for the, I'm trying to recall, Miss Councillor Jarman, your specific representation in relation to the duty to cooperate. Briefly.
Thank you. So I think we all know the reality, and I suspect you've seen it in the documents, that simply being connected to Sandown for nitrate neutrality doesn't really cut it, because the figures I think you've got in many of the representations about discharges along that route are substantial. Thousands of hours of discharges through combined sewer overflows, adding to the nitrates in the Solent, which is supposed to be one of those protected areas. I think the other point that was raised about commonality with other authorities, because we are an island, is something which is perhaps in many ways unique to us. So one could say that, you brought up the point of Ryde and Portsmouth, but the reality is that's not simply limited to transport costs or to the shipment of goods or of labour. It impacts the island in many other ways. Just to give you an example, many of the health services that we do not have any longer on the island are provided at Queen Alexandra at Portsmouth, or indeed at Southampton Hospital. So patients from the island need to go to those places for treatment. We also have the example that goods coming onto the island are inherently more expensive, and I'm sure everybody involved in the building trade will nod vigorously when you realise that many of the costs are in some cases double. So the impediments that it causes to us as an island go well beyond what they might do on the mainland to two adjoining authorities who have an impact with each other. Not just the transport of labour and goods, the provision of health services, the infrastructural issues that we have. It's a very broad issue, and I would invite you to consider that matter when you apply it to the island, perhaps in a slightly different way than you would to two conjoined authorities on the mainland.
Thank you for that. I think that's reflected through the various statements of common ground with the I'll call them the nearest authorities, as you say, where there are the very connections. I'm just going to briefly touch on the first part of the habitat regulations, and then we'll probably have a brief mid-morning adjournment. So obviously the council's undertaken a habitat regulation assessment, I think, prepared by LUC consultants. Note the statement of common ground with Natural England at paragraph 4.1, say that they have no formal objections to the conclusion of the habitat regulation assessment process. I was anticipating the RSPB here this morning. I was going to ask them about whether their point, and you'll have seen their statement, was more around the implementation of policies EV2 and EV3, and I appreciate the council's got proposed modifications that you want to put forward in relation to those policies, which we'll pick up next week in discussion. So maybe the RSPB will be with us for that point. I don't know if the council at this stage wanted to pick up anything specifically that was from the RSPB's representations, or whether you would agree with us that that's probably a matter we will come back to.
Well, so we would agree with you. We saw what they put into their hearing statement, but they did seem to be very much focused on wanting to see wording changes to the local plan policy framework to ensure that it, as it were, properly captured all of the requirements of the habitat regulations, rather than suggesting that there was anything deficient in the habitat regulations assessment itself, which obviously, as you will know, is an exercise that the council will have to repeat in any event when it gets to the stage of adoption of a plan in the light of whatever changes may emerge from modifications. And I think we saw the points that they had raised to the extent that they're still outstanding in the light of some of our suggested modifications from the discussion with Natural England. We saw their points as really being soundness points on the wording of the policies, and not in reality points that go to the regulatory compliance or otherwise of the habitat regulations assessment work.
Maybe the RSPB will join us next week as we look at those two specific policies. Yeah. Okay, it's just gone 11:15, so I think we'll take a short break now. I'd like to be back in this room at 11:30 because we've still got quite a bit to cover this morning, and I know quite a few people are here for matter 2, which we need to get to probably hopefully before lunch. You'll be pleased to hear. So if we can be back in this room, please, for 11:30, and we'll continue the matter 1 discussion. Thank you.
Normally there.
Okay, it's gone 11:30, so I'll resume the hearing session, please. And we're still on matter one, issue 3, and the habitat regulations. I just wanted to follow up with the council first in relation to the set out in our matters and issues question 1.12. In terms of obviously the habitat regulation assessment itself looks at the proposed allocations in some detail and recommends specific mitigatory measures where necessary to enable the conclusion on the plan in terms of the appropriate assessment. There would be no adverse impact on the integrity of various sites, and our question was really about whether it was sufficient to have some of those kind of recommendations or outputs from the habitat regulation assessment process effectively in appendices to the plan where you set out the site specific requirements rather than within, could be an alternative approach of specific policies within the plan, and whether we should be concerned about the effectiveness of things. I think it comes to a wider point about putting things in appendices rather than as a specific policy. I think the council's obviously resistant to that, partly on, I think, the view that it would make the plan unwieldy, I think is the word you've used. But you are suggesting some additional text, I think, to try and sort of signpost to that part of the plan. But I'll give the council the opportunity if it wants to say anything further in response to MIQ 112, and perhaps whether our concerns can be assuaged in terms of the balance between what's in an appendix and, say, an alternative of putting a site-specific policy within the plan that would set out those requirements on an individual site basis.
So if I go first and then Mr. Brewer can add if necessary. I think we start from the position that the plan, i.e. the document that is the statutory development plan once it becomes adopted, includes everything which is the text within effectively its covers. So the appendices are as much a part of the statutory plan as the text. And so what we think is important in terms of assuring compliance with the habitat regulations is that there is a clear signpost between policy language and a requirement to adhere to the content of an appendix. And so we think that we'd already provided that in particularly, I think, is it the language in policy H2, but we're certainly not averse to the idea of making things, as it were, as watertight as possible with habitat regulations, simply because of the onerous nature of that duty. So we're not averse to the idea of, in a sense, clearer signposting, but we also do want to have, as it were, an eye on the pragmatics that if given the number of sites, that to put all of that language into individual policies we think is too cumbersome. And if it's not necessary in order to achieve, I say, that signposting, we would say you don't need to go there. So I think that's our kind of position, I say, but we start from the point that the appendices are as much a part of the statutory plan as the text, and it's only at the moment under the legislation the policies map which sits in that curious situation, but the actual appendices would not be outside of the plan, they're part of the plan.
Too cumbersome or too unwieldy to treat housing sites similar as to the approach you've taken with employment sites. Mr. Brewer.
Yeah, it's probably just worth adding. I think that one of the other matters we suggest listing the housing allocations in policy. So that, in combination with perhaps that additional paragraph of 7.22 moving into policy H2, would hopefully provide that assurance then that all of the sites that are allocated are listed in a policy box, and that 722 wording is there as well.
In follow-up to that then, if we were of the view that, yes, changes to the plan at paragraph 722, possibly in policy H2, I mean, instinctively, as I sit here now, they feel like proposed main modifications that should be consulted on. The council has an alternative view to that, but this is fairly minor stuff that doesn't need to be.
I think this is one of those ones where clearly things can only be additional modifications if they don't alter the substance of any policy of the plan. Whilst we might say, well, it's already implicit in there, I think we would think that this would be one where you would err on the side of caution. And if one was to put, as it were, more a clearer framework linking the policy requirement with the HRA requirement and the appendix, I think we would err on the side of caution and take the view that that ought to be dealt with as a main modification rather than under that rather looser umbrella of additional modification.
I would similarly on the side in this area on side of caution, and then allied to that in follow up to our MIQ 114, I think the council is proposing additional text in Appendix 3. This is where, if memory serves, it's a combination. I think it's for a site that has planning permission. Then also for two of the proposed allocations, effectively a further requirement for those sites. That's, I think, going back to the point you made, Mr. Bedford, as a requirement. I think this is certainly main modification territory. Obviously, the council's responded to that particular question in terms of this proposed modification. Is this something you've discussed with Natural England, or has come out something that's come out explicitly through the habitat regulation process, and your reflections on it?
Yeah, it's come out through the HRA process, and so hasn't been part of the detailed conversation with Natural England to this date, but we're happy to have that conversation. And obviously, if it was in those main modifications, then obviously they would be one of the parties we consult on that, so they'd have the opportunity then to comment. As I say, in terms of that proposed modification under 1.14, it was effectively just an additional flag that fell out of that HRA. So yeah, if that appears as a main mod, then naturally we'll be consulted on that.
Thank you. I've got no further questions. I wanted to follow up in relation to the habitat regulation. I think just on that last point as well, obviously Natural England have signed through the statement of common ground that they don't object to the habitat regulation assessment outputs. So in a circular fashion, I'd be surprised if they would object then to the proposed changes to Appendix 3 in terms of site-specific requirements. I was possibly going to ask some questions now about nutrient neutrality, but I think I'll leave that when we come to some of the environmental discussions and what it might mean in terms of also for the housing requirements. We may touch upon it briefly tomorrow. So I'll park that for now. So there's nothing further I wanted to raise in relation to the habitat regulations. So okay, I'm going to move on with the remainder of the matter one agenda. So our issue 4 is climate change. Obviously, we have to report specifically in relation to how the plan, in sort of general terms, deals with the issue of climate change. We appreciate that the plan contains obviously policy CC1 as an overarching kind of spatial policy. Obviously, pick up policy C11 and net zero next week under matter 5, but just in general terms, the council could just briefly outline what they would consider to be the kind of key climate change issues you think this island plan strategy needs to kind of address and tackle.
Thank you, sir. So yeah, our hearing statement 1.19, I guess, touches on some of this in a bit more detail. And I suppose the starting point when we think about climate change is the declaration of the climate emergency by the council, the climate environment strategy, which the council has in place and has been approved through full council as well. So that almost sets the kind of framework for which the IPS then works from. So there are a number of specific policies within the plan which look at some of the issues that you would consider to fall within that kind of remit of climate change. So we have a number of issues around flood risk. We have a specific policy around ground instability, and I think that's especially important given some of the recent events that you may or may not have seen around the landslides we've experienced down Ventnor over the last kind of 12 months or so. And I think that there's those wider issues around, you know, one of the purposes of the policies of the plan is to deliver sustainable development, and by doing so, almost explicitly that should help address climate change because you're delivering sustainable development. So you've touched on the net zero policy, which we'll no doubt have a detailed conversation around. Again, we're looking at general support for renewable energy, whether that's renewable energy generation sites, solar parks, that kind of thing, which we're now required to do by the NPPF. And I think design as well, really important. So design and layout of new development plays a really key role when you're looking at climate change. So we've got a number of policies in the plan that do that, and then looking into transport as well. So one of the key points around our transport policies is that 20-minute neighbourhood kind of principle, which is emerging out through our local transport plan, and that ability for people to be occupying a home which is in close proximity to all the facilities they would generally need, as well as being close to open space as well. So I think all of those things in combination will work together to address as much as a land use plan can the issue of climate change. And I say, notwithstanding that kind of overarching strategic policy at CC1, which seeks to make sure that the planning policies align closely with the climate environment strategy that the island has.
Thank you for that. We will return to various elements of that through subsequent hearing sessions. So that's helpful in terms of a general overview in terms of the council's approach to climate change. I'm going to move on and deal with sustainability appraisal now. Obviously, we've got document EA2, the integrated sustainability appraisal of June 2024 that accompanied the regulation 19 documents. Can the council just advise us who prepared that document? Has that been an internal in-house production?
Yes, it was. Yep, it was internal. Yep.
Thank you for that. We'll obviously return, I think, through various discussions when we come on to particularly around things like site selection. I think we'll invariably come back to detailed parts of the sustainability appraisal, but I think I just want to pick up at a kind of high level the approach that's been undertaken, and it's really in response to I think RMIQs at excuse me, yes, 1.22 and to a degree 1.23 as well, and this issue about looking at kind of reasonable alternatives for various kind of policy options, reasonable alternatives that might apply in relation to specific sites, and whether the sustainability appraisal takes us through that process in terms of, say, for example, on a policy option, pick an example at random, affordable housing. Obviously, in this plan, you're looking at 35%, which is used as part of the sustainability appraisal process, with potential alternatives in terms of lower. They sound like Bruce Forsyth, higher or lower scenarios to then kind of inform through plan making. This is the preferred approach, and that's what we've gone for. Because looking at the regulation 19 sustainability process, quite clear you've looked at the policy that's in the plan itself, but I'm just trying to find out where you've kind of, if you have and where you have looked at that kind of process of kind of reasonable alternatives.
At this point, I'm going to pass over to my colleague, Chris Mills, who's going to pick up the start of this answer.
Okay.
James, yes, sir. So the story in terms of the sustainability appraisal starts with the previous plan version, so back pre-2018, but the 2018 sustainability appraisal considered all reasonable alternatives. And this included testing different levels of growth, ranging from the standard method, objectively assessed need, meeting and exceeding it, and also all different variations of policies at that time. And it then accompanied the consultation on the plan at that time. Subsequent to the work carried out after consultation of 2018 plan and the sustainability appraisal to understand what would be an island realistic in terms of delivery, quantum of developments, and the overall number, the identification of reasonable alternatives has been informed by the objectives to be achieved by the plan, including making provision for a scale of growth that is deliverable in an island context. So just to put some more meat on the bone of what that means. So the most up-to-date sustainability appraisal has considered reasonable alternatives to the spatial strategy. However, it is a document that assesses the level of planned growth and how best to spatially approach that, set out within CD1, the Island Planning Strategy Submission version, 2024. This level of planned growth is justified by the evidence in documents HO16, so the IPS Housing Evidence Paper A, residential, and EC1, Isle of Wight Employment Land Study, final report, and that was January 2022. In addition, given the evidence base and the Council's assessment of the scale of housing growth that is realistically deliverable, the Council does not consider that an option of higher levels of growth in excess of what is realistically deliverable would be a reasonable alternative. Not given the identified needs and the objective of the IPS to meet as much of that need as is realistically deliverable, does the Council consider that an option of lower levels of growth would be a reasonable alternative? In summary, all options of growth were tested with the previous version of the plan in 2018, then taking into account the consultation responses and then subsequent work we did, both in terms of looking at monitoring and all the evidence base supporting work that was done for us. That then set a quantum that then steered what happened in the subsequent sustainability appraisal. And just briefly on sites, so the sustainability appraisal assessed all the sites that came out of the SHLA process. It didn't make the site selection process. It just assessed them in terms of how they performed against the criteria, the objectives of the sustainability appraisal. Those sites then went through the process of site selection in the plan work, which is then documented in evidence paper B, which I think is HO17.
Thank you.
So could I then just add, in terms of this issue about sustainability appraisal and reasonable alternatives, the first point is that sustainability appraisal is intended to be an iterative process, and as you make a journey along the route towards producing a plan, there may well be alternatives which are considered at one stage and then discarded, and there isn't a requirement to go back to revisit the discarded alternatives unless there is a material change of circumstances, so that you can, as it were, clear the decks, narrow things down as you move on the journey. So that's the first point that we would make. The second point is, again, I'm afraid it is a little bit of a legalistic point, but the question of reasonable alternatives and what they are is not, as it were, a hard-edged question that only admits of one answer. It's a question which is a matter of planning judgment as to what is reasonable given the objectives that a plan seeks to achieve. And so far as the regulatory framework is concerned, the plan maker has to exercise that planning judgment in the first instance and has to formulate what it considers to be reasonable alternatives, which it then considers in the context of sustainability appraisal work. From a regulatory compliance point of view, there is a distinction, we think, in terms of your role between two different questions. One is the legalistic question, which is, has the council undertaken a sustainability appraisal which meets the terms of Section 19 of the 2004 Act, and by so doing meets the requirements of the SEA directive and the Environmental Assessment of Plans and Programmes Regulations 2004. And in relation to that, I say it's not, we think, necessary for you to have to, as it were, second guess or validate all of the planning judgments that the planning authority has made in that process. That's one exercise. What you have to, I say, be satisfied, have they actually just done it? And I'll come back to that point in a moment. There is a separate matter, which is obviously the soundness test of justified in paragraph 35 of the MPPF, where you are, as it were, able to get into the gubbins, as it were, because you are, as part of your consideration of that test, asking yourself whether this is an appropriate strategy given the reasonable alternatives. And there you are able to think more widely about whether or not there are reasonable alternatives which ought to be considered in the context of, is this an appropriate strategy or not? But it is quite important to, I say, make a distinction between the legalistic issue of simply, have they done what they need to do to meet the regulatory requirements, and the merits issue of, well, have they met that justified test in terms of soundness? So if I can, having made that distinction, if I can then go back to that, the legalistic bit, the courts have helpfully used a phraseology in some of their cases where they say, well, what is important when you're looking at sustainability appraisal and strategic environmental assessment is to ask, has the plan making body addressed the issues that the regulations require them to address? But the court is not interested in what it has phrased the quality of the address. So if you've done it, even if you might not have done it in a way that the court might think is perfect, that's sufficient. The quality of how you've done it is not a legal issue, but I say there is a separate point, which is your soundness test, which comes at a later stage. And so when you then look at the documentation in the ISA and you ask yourself, well, did the council make a reasonable planning judgment as to what it considered were reasonable alternatives or not? To which we would say the answer is yes. The quality of what they've done is not directly a matter that goes to that regulatory compliance matter, but obviously it's entirely open to you when you're looking at soundness to take further views on that. So I think that's part of the context that we do want to stress, because I know that there have been representations, not actually from anybody who's I think present in the room today, but there have been representations made to you about the approach to reasonable alternatives. And I say we would think it very important that kind of distinction between a compliance issue and a soundness issue is identified and then followed through in obviously your deliberations. If you would like us to provide anything further on that, the legalistic side of, well, why do we say that and what are the cases, we can do that, but we're in your hands on that as to how much you think that we're going over ground you're already familiar with from other cases or not.
And as you say, I think it's the representations. Is it now planning for Rapley's? I think provide a summary of various court cases where unfortunately plans have come unstuck on the issue of sustainability appraisal and SEA. So pick up the first theme, if I call it the kind of legalistic compliance. Can I understand from from what Mr. Mills was saying, for some of this assessment of reasonable alternatives, what we actually need to do is to go and look back at the integrated sustainability appraisal at the previous regulation 18 stage, which I think the council has now provided as an examination document, because I think that was one of the concerns in the statement as to people from a transparency point of view. I think people were saying, where did you look at these kind of reasonable alternatives? We can't find it. So I think Mr. Brewer, you're nodding. Mr. Mills, you seem to be nodding. That we need to go back to the previous 2021 Reg 18.
Yes, so effectively, and I think it comes down to the last sentence really of the question on the agenda around that audit trail. And so I think there's probably a piece of work there, if that's something that you would find helpful, would be just to set out that audit trail of the ISA process that we've been through. So the 2 Regulation 18s, both of which had a supporting sustainability appraisal, and obviously the Reg 19 plan as well, and just set out which each of those documents did. And I think it's an approach that was taken at the Worthing local plan examination, where a similar issue was raised, and the inspectors took the view that having that kind of audit trail document of just the journey of the ISA through the process was really helpful, because you say we've submitted the one that supports the plan that we've submitted, but there's a lot of work that's gone on before that, which doesn't necessarily perhaps come out.
As I'm sure Mr. Bedford's aware, through the court process, it's been held, so I'm going to slip into shorthand. I always want to call it SA. Apologies, it should use its full term for everybody, for sustainability appraisal and strategic environmental assessment regulations. This is something that we can deal with as part of the examination process. It's not too late if we left this discussion and following further deliberations of the issues felt, well, we may want a bit more within the final sustainability appraisal to provide some further signposting to say, well, we looked at these options at a previous stage, see this document, paragraph or table, whatever, and they were discounted. They were not reasonable options to kind of take forward, and that may be a way that kind of again provides us with a bit more assurance that the compliance legalistic element has been satisfied, even if we have to go through a kind of an audit trail to find it.
So yes, that's right in terms of that issue. But can I just clarify? I think this is just a factual point. I think the representation from Now Planning had referred to those earlier sustainability appraisals of the 2 Regulation 18 plans, and had only suggested there was a difficulty about locating one of those. And so I think it's right that that's the one that you asked us to provide. That is the sustainability appraisal from 2021, which supported the 2nd Regulation 18 plan. But in terms of this audit trail and a note that Mr. Brewer was referring to, we think probably you also would need to have the opportunity to see the original Regulation 18 ISA from 2018, i.e. the one that accompanied the first Regulation 18 plan, because it's that Regulation 18 plan, i.e. the 2018 Regulation 18, which considered the housing growth on the basis of meeting a level of what was then the standard method figure. And so you probably need that ISA to understand the journey and that, I say, that iteration between the different ones. So I think, and that's not one at the moment that we've provided into, have we? Ah, right, so that one's gone in as well. I see, you've now got the 2018.
I'm again, Mr. Brewer, as a reference for that document now.
Yes.
Right. Well, that's helpful. So that clarifies that point. And so we're just in terms of us making a note of action points, were you wanting from us, as it were, a note, which is this kind of audit trail of that journey? Or do you think now that you've got those documents, you don't need a note because you can look at the documents?
I don't think at this stage we'll be looking for a note. If we've got both the source documents, is there anything further we then say reflection after these hearings? You'll undoubtedly get it in the first instance, a post hearings kind of letter. And I think as part of that, if we felt need to see a bit more work undertaken in terms of the sustainability appraisal, we could identify it as part of that in terms of whether it's clearer signposting or referencing through that process. But I think on your second strand, Mr. Bedford, when we come through the various topic discussions, I think we're invariably going to come round to, as you say, that kind of element of judgment in terms of what's an appropriate strategy, particularly around the housing numbers, which will be a key session tomorrow morning. And undoubtedly, when we come back to some of the site specifics, yeah, and you'll undoubtedly, I think, in relation to the housing numbers, obviously we're going to be hearing from those who think that meeting the standard method is a reasonable alternative or a reasonable option, or alternatively those who feel actually what the plan's doing is too much, and the island justifies its own separate lower housing need figure. But we'll come on to the substance of that through the individual sessions. So at this stage for sustainability appraisal, we'll have a look at those two documents that the council's now provided, and it'll be, I think, as part of our post hearings assessment, we indicate what additional work may need to be done. Thank you. Look, I've got no further questions in relation to sustainability appraisal. I think that's probably the substantive issue in our minds, is just understanding where that assessment of reasonable alternatives was undertaken and why possible options were discounted, because it has been I think there are more cases out there than the ones referred to by Rapley's where this has been taken through the High Court. So you'll understand our nervousness about making sure the plan is in the right place for this. Okay, just very finally then on matter one, before we move on to the next matter, which I understand people are here for with us this morning. I'm going to move on to issue 6, if I may, and it's strategic policies. Obviously, the plan does identify and make clear which are strategic policies. I think Mr. Brewer, on reflection, response to RMIQ 125, council thinks that perhaps some other policies should now be identified or made clearer that they are strategic policies. I think in our view that would be a main modification, because it would have ramifications for those who are potentially subsequently preparing neighbourhood plans, because obviously they'll be under a test of general conformity with those policies. I mean, just for the benefit of the room, Mr. Brewer, so this is really in relation to some of the kind of call them kind of key sites or key, ensuring that they're not kind of overtaken by subsequent events.
Yeah, that's it. Thank you, sir. And I think that as we set out in our response to 1.25, it was just almost to make sure we're taking that belt and braces approach, really, that whilst we identified policies H1 and E1 as strategic, and obviously they are the policies that set out the level of planned growth from a housing and employment perspective. It's just following that on and making sure those sites that then allocated to deliver that planned growth also fall into that strategic bracket. So it's just to make sure that the plan is doing both of those things. So we absolutely agree that would form a main mod. So yeah, happy with our response on 1.25 on that one.
Thank you. And then just finally under matter one, I think as Mr Bedford just referred to a moment ago, the unusual position of a policies map as technically not part of the, not a development plan document. I mean, obviously at this stage, we have that in front of us, asked kind of various questions around whether it be necessary at this stage to modify it. I just wanted to be clear from the council, you're indicating that you're going to add something in relation to Great Crested Newt District Licence Scheme as a further layer.
Mhm.
From the council's perspective, why do you think that's a necessary change to the policies map to make?
Yeah, so the Great Crested Newt District Licence Scheme is the it's another mitigation package which has been the Isle of Wight has entered into, and effectively it's a company called Nature Space who provide kind of strategic level mitigation for great crested newts, and so much in the same way as the bird aware scheme works for overwintering birds. A developer has the option, if they wish to access that district licence scheme, so they don't have to go through their own site-by-site licensing process. They can just effectively make a contribution towards the district licence scheme, and then the mitigation is handled by that body. So it's just basically to make sure that that the maps that support that district licence scheme appear on the policies map, so everyone's aware of if they are bringing a particular site forward and that district licence is available, then they're able to access it. So that's why the suggested addition to that map is made.
Thank you for that. And then I see obviously then a further reference, I think, to just update, is it in relation to this, the marine plan? I think that's more, and then there's a technical change in terms of, I think we'd identified issue whether there's a proposed SPA. I think it's addressed in one of the previous questions. So I think it, yes, under MIQA at 118. So there's that, it's no longer proposed. It is actually a formal.
Yeah, correct. So it's just taking the P off before on the layer. So yeah.
Thank you. I mean, it's a technical matter, but as we go through the plan examination, obviously there are proposed main modifications. There may be additional modifications that the council itself can make of its own volition that don't go to the heart of soundness, for want of a better phrase, tidying up presentation of the plan, etc. And there'll probably be a need to do a separate schedule of proposed changes to the policies map, although it's technically not to the point of plan soundness. It's, I think, it's something that we'll expect to see consulted upon alongside any proposed main modifications. Thank you. That concludes what we wanted to cover by way of matter one. So it's just gone. It's past 12. I think our intention at this stage is now to move into matter two directly and to deal with some of that before we take adjournment for lunch. Although what I am going to have to do, I'm going to have to take a short adjournment because I think I've left my agenda and paperwork in the retiring room for matter two. I'm going to take a short break for literally a couple of minutes while I get that agenda. So I'd like to restart 12:15. And for those of you who've patiently been waiting for matter two, we'll start the discussion there. Apologies, bear with me. I'll just get my paperwork. Thank you. Okay, it's just gone 12:15, so I'm going to resume this examination hearings, and I welcome people. We now start on matter 2. We're dealing with matter 2 in a number of hearings. So today we're looking at, well, effectively the wider umbrella of matter 2 is the amount of development that the plan should be seeking to accommodate. This morning, we're going to look at the plan period over which the amount of the plan should be seeking to deliver a quantum of development. And then we're going to move into employment land and economic policies later today, and then pick up the housing numbers, which is probably all soundness issues are equal, but perhaps some are more equal than others, and probably the housing numbers is probably going to be the one we're going to focus on quite significantly. I'll dispense with the normal introduction to this session because you've also heard from Mr. Steen this morning. I've got a number of questions, in the first instance directed primarily to the council. And I'll try to bring in other people as we go along. Obviously use the convention of your nameplate up to signal that you want to come in on a particular point. We'll work through now to around about 1 o'clock-ish, when there'll be an adjournment for lunch, and then if required, we'll carry it. We'll certainly be talking about employment needs and employment policies this afternoon after lunch. But I'm going to start the first part of this matter 2 discussion looking at issue 1, which was the plan period. We picked this up in our matters, issues and questions 2.1 and 2.3. Obviously, this is a plan that contains a number of strategic policies. It contains 2 key priority sites that are likely to extend beyond this plan period in terms of their delivery. So having regard to paragraph 22 of the December 23 National Planning Policy Framework, which says that there should be a minimum 15-year time horizon from plan adoption to the council, are there the mitigating or particular circumstances for the Isle of Wight to have what we think will be around about a 12-year post adoption plan period.
Thank you, sir. And I guess again, the short answer is yes. The council do think there are mitigating circumstances for that reduced post-adoption plan period. And I think in our hearing statement we set out that I think on the basis of a plan being adopted potentially later on this year, that would effectively leave 13 kind of monitoring years if you take it in that reflection, and plan starts, as we'll come on to, potentially on the 1st of April 2024. I think the main mitigating circumstance is the kind of ongoing national change, which was kind of running parallel to our plan preparation process. And paragraph 236 of the NPPF, the December 2024 version. Obviously, that's not what this plan is being examined under. However, as we touched on this morning when it relates to the LDS, it is something that you've got to take account of. And I think as we set out in our response to 2.3, we are one of those authorities who will be caught, it's probably the wrong word, who will be expected to effectively start work on a new plan as soon as possible because of the level of housing that we're looking to take forward in this plan. So even if we were to adopt it, paragraph 236 sets out because of that quantum, we then have to be expected to start work on plans straight away. So given that, again, one of the kind of themes we're hearing, certainly from the previous government and this government, is around that compressed plan making process and trying to streamline it into something that perhaps doesn't take a decade, but perhaps can be turned around a lot quicker. Even if we were to look at adopting this plan back end of this year, really early part of next year, if we were then looking to start work on the next plan, and we had a condensed time, even if you looked at 5 years, then we'd be effectively looking at adopting a new plan around 2030. So when we're looking at the particular back end of this plan period, so 2037 to, for example, 2040, effectively that's going to be superseded by the next plan we produce anyway. So I think our view is that mitigating circumstances does exist for that reduced plan period. and that's clearly set out in current national policy that we'll be expected to comply with.
I think it's probably fair to say, as I think we have said in the matters statement, there's in a sense a prior factor which also needs to be considered before we even got to the new MPPF, which is obviously you read the 2023 MPPF as a whole, and what one sees is that paragraph 22 of the MPPF doesn't sit in isolation. It sits within a whole series of paragraphs that relate to plan making. And if you take from the very first paragraph of the MPPF, paragraph 1, on a journey through paragraphs 1, 12, 15 and 33, they all emphasise the importance of plans being up to date and being kept up to date and having up to date policies within them. And the current adopted core strategy predates the very first MPPF of 2012. It was adopted in March, but it took no account of the MPPF because its examination and its consideration preceded all of that. And it only has a plan period in terms of the stated plan period that runs to the end of March of 2027. That's, I think, set out at paragraph 1.15 of the core strategy, which I think in the library it's now GS1 is the reference. And there are a number of policy areas which, in a sense, anybody who's been involved in planning over that period will know, but we've drawn attention to, where, in a sense, the approach that might have been taken pre-MPPF in the run-up to 2012, which is the policies of the core strategy, is no longer a good fit with what one would do now if one was policy making. And I think we've drawn attention in particular to design, to the approach to dwelling mix and to affordable housing. One could also refer to sustainable construction and a whole series of environmental measures where, in a sense, the world has moved on, but obviously the core strategy has not. And so I think we do see it as a key benefit of maintaining the present plan making, that we're able to get this plan adopted so as to provide a suite of up-to-date development management policies. And we've also drawn attention to the pragmatic point that were you to seek to extend this plan period to go forward to 2040 or thereabouts, as well as the points Mr. Brewer has already outlined about, well, in a sense, the utility of that because of other plan making strands through the new MPPF. We've drawn attention to the fact that you would need an evidence base to cover that further period. And it's not simply a matter of, well, you could just roll forward everything for another 3 years, because in terms of some of the needs, they would need to be reappraised. Obviously, things like the standard method is as it were, such a mechanistic system that you can just do it for that one by just adding extra years, but you can't do that for other things, particularly we refer to employment, affordable housing, and so on, where you would actually need an evidence base. And you would also need an evidence base in relation to the impacts on constraints, i.e. environmental constraints, environmental capacities. And if you say to yourself then, well, if you're doing all of that extra work, it will take time to do that, it will take resources to do that, and then that sort of underscores that utility point that if there is another strand of plan making going on, because the council, to meet the new MPPF, is going to have to produce a new plan, you then begin to identify, well, are we just hitting paragraph 22's 15 years almost for the sake of it, as opposed to are we achieving sound planning in the circumstances? It's fair to say that some of the representations have referred to examples where some of your colleagues examining other plans have taken the view that the plan needs to be extended for 15 years. And it appears from those examples that it was practicable to do so in the context of those examinations. We don't think that that is so here without inordinate delay and undue use of resources. We have not given you, as it were, a list of other examples where your inspector colleagues have taken a different view, but there certainly are relatively recent examples. I think Mr. Brewer did refer to Worthing was, he referred to it for a different reason, but Worthing is an example of a plan that the inspectors accepted a less than 15-year period. There are also examples at Hart. I think Worthing was in the examination report was in October of 2022. Hart, i.e. H-A-R-T, the place in Hampshire, their report was in February 2020. Calderdale in Yorkshire, the report was in January 2023. And then Barking and Dagenham, where the report was in August 2024. They're all instances where inspectors accepted a less than 15-year period for, as it were, pragmatic reasons. Obviously, they all turn on their own particular circumstances, so we weren't going to sort of trouble you with all of those unless you want that further information. But we think that when you look at the island circumstances in terms of where it is now and what the practical position would be, that there is a good reason for departing from the 15-year post-adoption period in paragraph 2022.
Thank you. If I can bring in others, and I think we'll come back to some of these points. Bring in Mr. Beraint first for the Home Builders Federation.
Thank you, sir. I think what we've heard from the council is not so much a justification as for want of a better word, excuses in terms of why it hasn't been undertaken. Because we look back in terms of the plan preparation. The plan preparation started back in 2018. Consultations on Regulation 18, 2021, and the council haven't moved forward in terms of looking at that plan period, in terms of updating it. Looking at the 2021 Regulation 18 consultation, there would never have been an expectation that there would have been a 15-year plan period on adoption, so that it could have moved forward from that 2021 period. So there was delay. The council's own delay in terms of bringing forward this plan, recognising there is change, but it did not look to adopt a sound plan period, which the NPPF clearly says is a 15-year post-adoption. And I think it's that point, sir, that isn't really addressed by the council. It hasn't moved that forward. It would seem that it's a decision based on not wanting to deliver further housing across a policy compliant plan period. We don't know. It could be other factors. But within that period and that delay, the council could have undertaken the work required in order to ensure that it had a policy compliant plan period. So we're looking at almost reasons why they're putting forward to you, sir, why you should allow them to not extend the plan period, in terms of, oh, we want a plan to go forward to bring forward new development management policies, and I would perfectly agree in terms of the need for a plan-led system. But we haven't had a plan. The council haven't brought forward that plan for the last, since 2012 was the plan was adopted, as we've just heard, in terms of the prior to the NPPF. So had an out-of-date plan for a number of years now, sir, yet the council hasn't brought it forward. And suddenly now is the point at which it's saying, actually, we don't want to delay any further by looking to extend that plan period and looking to identify, and as the NPPF clearly says, meet needs in full across a plan period and a policy compliant plan period at that. So I think those are my concerns broadly, sir, in terms of what the council are proposing. And what the council have said in terms of mitigation. And I think there is a need to look at all those reasons but also say, actually, there is a need to plan across a policy compliant plan period. And then paragraph 22 clearly says that lots of local authorities, some local authorities haven't met plan periods and recognise that. Others have been asked to do that, but actually the vast majority just come forward with plans that have a sufficient scope within them to ensure that where there is delays in plan making, whether it's examination or whether it's preparation, do have that 15 years on there. So it's not a difficult element to look at in terms of plan preparation, ensure that you have the evidence and have the capacity in order to deliver the homes across a policy compliant plan period. So I think that's my main concern is as to what the council's justification for it. I don't think there is a justification. I think it is mitigating circumstances, I think is possibly a generous way of calling it. In terms of if you were to decide that a policy, a plan period wasn't, recognise that there are requirements through the new NPPF for the plan to for the council to prepare a new plan immediately. I think, or I think it's from 2026. As soon as we have the relevant legislation coming forward. I think my concern with regard to just having that and whether there is a need for a specific review policy in the plan, if you were to not extend it, I think there is a need for one, but I think it's one that needs to have a teeth within that to ensure that that plan does come forward. We've got a local authority here that is 13 years from its last plan that we're having adopted. It doesn't fill me with the confidence that there will be significant progress within that time frame without some sort of review policy that has teeth. I think others have probably mentioned, I think we might have mentioned in terms of the Bedford local plan is one that probably the only one I've seen which has an effective review policy that actually has teeth and actually their local authority has moved forward with, in terms of saying, you know, if you don't submit after 3 years, then the policies relating to the supply of housing will be considered out of date. And I think that is one to consider. And I think especially because of the slow nature of plan making within the island and from the Isle of Wight Council. So I think those are our broad concerns, sir, in terms of not having a policy compliant plan period, but also in terms of if there isn't to be one, there has to be a strong review policy. I'd say there probably needs to be a strong review policy in there anyway, given that we're in this transitionary period. I think there are some elements in terms of the 20% buffer in terms of housing supply from 2026 within the new NPPF, but I don't think that's significant enough within this context. I think there needs to be a very strong review policy, sir. Well, I think anyway, but I think that's especially important given the shorter plan period. Thank you, sir.
Thank you. So just if I can be clear on the Home Builders Federation's position, so you'd be advocating to us for soundness, the plan period should be extended to 2040, 41 in terms of a 15-year from point of adoption.
Yes, sir. I should be 2040, 41. I think would be the with the period. Obviously, it depends when it. I'd assume in terms of this examination, we'd be looking at main modifications. The earliest adoption would be the end of this year. Would be my guess in terms of that. So we're probably looking at 2040, 41. I think. Thank you, sir.
We've heard from the council this morning from Mr. Bedford. I think he used the phrase there'd be an inordinate delay. Were the council to go down a route of an extended plan period, and that has to be weighed against in the balance of the council's position of a benefit of getting a plan in place now. When I think about delay, I'm immediately going to a recent ministerial letter about pausing for no more than 6 months. Just the Home Builders Federation has anything further it wants to say in terms of the council's kind of position it wants to presenting? There's a benefit here now. We're getting a plan in place that will deliver in the short to medium term, and that outweighs any kind of disadvantage about delaying this plan examination.
I think I think partly it's a disappointing approach the council have taken not to actually submit a plan that looked across the plan period, and we're at a point now that, and you've been placing that point, sir, as to do you require that key element of national policy, or do you just move forward on that basis? I think if you were to move forward in terms of those circumstances, again, given the 6 month delay and all those that weigh up in terms of considerations, and a number of your inspector colleagues are having to make similar decisions elsewhere in terms of the delay. I think that is where, if you were to decide that, it was going to take too long to address. Whether it would, I don't know in terms of looking at that, but I think there may be other considerations about tomorrow in terms of housing need and how that's considered to be weighed into any decision. But also that's where I think a strong review policy is potentially necessary to ensure that the council does, and that their consequence does prepare a new plan on the basis of a fact that they're not meeting needs, they're very shortfall significantly of current needs, but also of future needs, that needs to happen and happen relatively quickly. And I think that's the important bit if you are looking and minded to recognise that actually it'd be better to have a plan in place, but it's ensuring that plan is placed there to deliver that short term, but actually a plan comes forward to deliver that longer term level of needs in a relatively quick manner. Thank you, sir.
I'll bring in others and then I will come back to the council in terms of what it wishes to say. So hear from your nameplate the other way around. Is it Mr. Beverley on behalf of Jackton Properties, please?
Yeah, no, thank you, sir. Obviously echo a lot of what's just been said. And to Mr. Bedford's point, obviously he's read other representations, and we have provided examples where the inspectors have decided that is a matter of soundness, the plan period should be extended. I think it's important to note that a 15-year plan period isn't particularly new. It's something that the council, it's been in iterations of the NPPF for a while. This hasn't came from, the 2023 NPPF moving the goalposts. It's something the council were always aware of. And essentially, I think the council have provided two broad reasons that we should consider in terms of mitigating circumstances. The first was that the council will, through the transitional arrangements of the NPPF, be compelled to do a plan review anyway. But I think as a fundamental point, the fact that you have to immediately do a plan review doesn't make the submitted plan sound. It's probably useful to refer back to Bedford. I know we mentioned it in our matter statements, and I agree with the comments of, apologies, of Mr. Bedford, that actually it was quite positive that in terms of trying to rectify and move forward the 2030 Bedford local plan, they put policies with teeth in, so i.e. there was implications if the council weren't to meet the deadlines that were provided there. But it's also a good example of why relying on plan reviews isn't necessarily the best idea, because the Bedford local plan was submitted in accordance with the requirements of the 2030 local plan. That plan's stuck in examination. Last week, the inspector's already been paused for a year. The inspector's granted a further pause of another 3 months. So relying on plan review is just kicking the problem down the road, and doesn't in itself make an unsound plan sound. In terms of the other kind of argument was the timescales and the practicability of it, and also the comment in relation to, it would be beneficial to have a plan in place given we have a plan-led system. But I almost feel like you shouldn't use the historic failings of this council to get an up-to-date plan in place as justification to let them off the hook, so to speak. That unfortunately is historic failings of the council, but again, wouldn't make the plan sound. And I think the final point was in terms of practicability. In the examples we provided, I don't think necessarily officers would agree that it was particularly practicable to do. There's a lot of hard work gone into it. We provided Error Wash as an example, where they're needing to look in new tiers of the spatial hierarchy. They're needing to do a comprehensive greenbelt review. Unfortunately, it wasn't that practicable. There's a lot of hard work to do it, but the inspectors there deemed it was necessary as a matter of soundness.
Thank you for that. Is it Mr. Salmon next or Mr. Long?
Thank you, sir. Just to say that the point was raised about whether we have some satisfaction that the local planning authority would move quickly to revising the plan, given the new MPPF, the housing methodology in terms of calculating need or whatever. I want to go back to your predecessor, the planning inspector from the current core strategy, who had Mr. Hetherington at that time, who found the core strategy sound just about on the basis that the local planning authority should move quickly to allocating sites and producing policies for the area action plans at that time. That never happened. We've never had any new allocations. We've never had any regeneration policies linking to the economy. And that's never been taken forward. And whilst the core strategy in its own right was a sound document, there was never the stuff brought forward in detail to give the investors the confidence in terms of investing in housing or employment, or indeed the ability of the planning committee, the Isle of Wight Council, to actually give fruition to planning decisions at that time. And that's been a major frustration to house builders and to those wishing to invest in the economy. In terms of this plan, to be frank, whether it's 12 years or 15 years, that doesn't matter to me as so much as that the policies and the allocations and the planning for need needs to be as up-to-date as possible and actually planning for need. I'll go back to a point that was raised in the opening statement, or indeed the discussion about joint working, that yes, we are an island, but that doesn't justify an exemption from meeting planning need. The island, the Solent, defines the island as a characteristic, but not one that makes it exempt from planning for actual need. And that's the biggest frustration that I've had in the last 10 years as a planning consultant working with on the island here.
Thank you. Mr. Long, next, please.
I think it's been well said. I mean, one thing that will come out in representations on a continual basis is, for example, I think the council, as in the actual planning authority, have struggled to get a plan over the line for reasons sometimes outside of their control, due to pressures arising. I think moving on to a next iteration of a plan would be quite expedient to do so. I say that because the NPPF places the 15-year requirement because it creates stability in a development process. A shorter period of time creates more instability. And what we have seen with delivery of both housing and employment, etc., is instability. Going on the housing part, by March 2026, it's our 30th year anniversary of when the last housing allocations were made, and there are consequences to those actions. So having a plan period that is sound and robust and gives the industry the stability to invest and deliver the needs of the island is an important factor to consider, because if the industry doesn't have stability, it weakens our position. If a review mechanism was considered appropriate, I do agree with Mark that it needs to have some serious teeth. And I don't say that to be damaging on the planning authority as making a plan. Though those teeth would give the ability of the planning authority to drive forward a plan within the council itself. If we don't have that teeth, then it weakens the position to move forward and advance subsequent updates to a plan. To me, it's absolutely essential if a review mechanism was being considered as a principle beyond the debate between 13 and 15 years.
Thank you for that. So if I can come back to the council then on at least two immediate issues. The first one I'll pick up is implications of kind of extending the plan period, and then we'll pick up the suggested modification people are articulating around a plan review type policy. So in terms of extending the plan period, I think the council, in response to our MIQ 2.2, kind of outlines some of the sort of the menu of work that would need to be undertaken. What's the council's response? I think it's primarily from Mr. Beverley. Correct me if I'm not capturing this correctly, but there's been a body of work around the plan. I think as mentioned to me at the start, under the sustainability appraisal discussion earlier this morning, there was an original regulation 18 that did look at an alternative kind of housing figure. So what would the council say in response to, well, there'll be some of this evidence will be there. You'll have done a strategic housing land availability assessment. Or you'll have evidence on other factors. Is your response or approach to MIQ 2.2 around what this could mean justified, or is it overly cautious, or is some of this additional or pre-existing work that's been done, does that assist, or is the council of view, well, there are issues around that if we were thinking about extending the plan period?
Thank you, sir. I think, yeah, I guess it's a bit chicken and egg, isn't it, a little bit? And when you look at our response to 2.2 and some of the issues that have been quite correctly raised, I totally understand the points around the confidence, if that's the right word, in terms of the council then taking forward that next plan. So almost the mitigation for not having that plan period. In terms of the pieces of work, if we were going to extend, obviously we've touched on those in 2.2. Some of that work does exist, albeit obviously the further you go back into our plan making process, the further away you are from, I guess, the being able to wholly rely on it looking forward again another 3 years. So that's one of the issues we'll have to consider if we were to look into that. Would be to which bits of those pieces of work would still be able to almost use the starting point for that additional 3 years. And obviously we haven't come to that decision because we haven't looked into that other than just flagging it in 2.2. So I think that's our kind of position on that. There may be other pieces of work as well that we would need to pick up alongside those listed in 2.2. And again, I guess the knock-on impact of the time of doing that then potentially prevents us from going into where we were going next. And we're thinking about minerals and waste planning, gypsy and travel documents, which we'll probably touch on later today as well. So I guess all of those things are weighing in our heads around that extra 3 years, which, as Mr. Bedford set out, from our perspective, is probably 3 years that we'll never get to under this plan for all the various reasons that we've explained. So I think that's where we're at on that kind of 2.2.
And so could I just add, it is with respect oversimplistic to simply say that, well, because you looked at a higher number in 2018, it would be robust planning in 2024 to simply pick up that work and drop it into period. I mean, it's quite clear that the 2018 work did not look to a plan period that ran into the 2040s. It was, yes, it was a 15-year period it was looking at, but it was a 15-year period that ended in 2038, may have been 2037, I can't now remember. But so the chronology is one that you couldn't simply carry it across. You would need to revisit that work. You would certainly need to refresh it as a bare minimum, but you would probably need to carry out new assessments and studies, particularly, I say, we're not just looking at housing numbers, we're also looking at housing needs. We're also looking, as I mentioned before, at environmental constraints. And so it isn't simply a case of the work's already being done. So that pragmatic point, I'm afraid none of those who've spoken today from the other side of the room has actually grappled with, well, what would be the implications in terms of timing of getting an adopted plan in place of the lengthy delay that would engender. So I do want to say something about the review matter and mechanism, but I think that's a separate topic. So I'll leave that until you get there.
Thank you. I think in terms of the plan period, I think it's probably fair to say from around the room and from the representations, I mean, the kind of the reasoning and the explanation or the articulation for it, just in terms of consistency with national planning policy, I think it's probably fair to say it's what does that then mean? And probably the bottom line is, if the housing requirement is to be found sound for this plan, it's probably close to an additional 1,350 additional dwellings. To go down the standard method, it's an additional 2,100. You can trust my maths. I mean, I think that's broadly where I think people are probably coming from in terms of I don't think people are articulating this from a perspective of, well, we need to release more employment land, but I do take the point about it's not simply a numerical exercise. There are other implications. That's something I think we'd have to think about and take from this discussion. If we were minded to go down that route, to then I think give the council the opportunity to sort of further out and say this is what it would mean and this is what we would have to do in terms of the time frame to do that. I'm not saying that will be our conclusion, but obviously that's something we'd need to think about further. I think give the council a further opportunity to set out a Gantt chart or whatever. This is what this would actually potentially mean. I'm not inviting the council to prepare that now. I think it's something we'd think about. The alternative that's been put forward as a way to deal with this issue is a review policy. I accept some plans have found that as the way to kind of navigate to plan soundness. I guess the judgment in our minds has got to be the effectiveness of that versus Mr. Brewer described it as being caught by the new NPPF, but obviously the implementation of the new NPPF. And I wonder if in our minds whether things are further potentially complicated by around sort of just plan making in general, in terms of what's potentially just coming down the track in terms of whether there will be a spatial development strategy, national development management policies, etc. Whether we need to kind of have that as part of our thought process. But I don't know if the council has an initial kind of reaction to the suggestion, well, if we weren't to extend the plan or alter the plan period, a plan review policy, I think with teeth is how people have described it, is a potential option here for the Isle of Wight.
So I think in the first instance, since it's before one starts thinking about the new NPPF and what, in a practical sense, it means, is if you look at simply the present regulatory regime of the 2004 Act, it already includes within it the requirement for every local planning authority to prepare a local development scheme, which is expected not only to set out the documents that are to be prepared, including obviously the development plan documents, but also the timing of the preparation of all of those documents. And it's worth emphasising that because the Act then requires, again as a matter of the statutory provisions, it does require development plan documents to be prepared in accordance with that local development scheme, including the timing of that. Hence your earlier questions to us about whether what we're doing at the moment is in accordance with the LDS. But the Act envisages that regime of requiring authorities to have a local development scheme and then requiring them to produce documents in accordance with that scheme. The Act envisages that can be policed by an external body, that's to say the Secretary of State. The Secretary of State is already empowered to issue directions to local planning authorities. First of all, directions to require them to update their local development schemes if the Secretary of State considers they're not up to date and they don't set out documents which need to be prepared. And secondly, to require local planning authorities under the intervention powers to prepare local development plan documents to his direction. So the mechanism is already in there that if the local authority, let's say, if we've put this new MPPF on one side, not that we can, but if we put this new MPPF on one side, and that wasn't going to be the spur that would require the council to get on with their new plan, and if we were just to assume that the present regime carries on, there is already within the system the ability for the Secretary of State to grab, as it were, the Isle of Wight by the scruff of the neck and require them to produce a plan which does the things that are needed. So I think in the first instance, when you ask yourself, is it necessary in order to achieve soundness to build in a policy of review? The answer is no, it isn't necessary because the legislation already includes that arrangement. Secondly, I think we would say, well, were you to still nonetheless go down that route, in one sense, given what we know is coming down the tracks, it will soon itself be overtaken by events because it is likely that whatever review period was specified would be subsumed within the new planning regime. And so that then again goes to the utility and therefore the soundness of making such a change. So I think we'd say for both of those reasons, we don't really see that a review mechanism is required. That said, you know, were you to want the reassurance of it, in one sense, I suppose we could live with it simply because the reality is it would be unlikely that it would actually end up being triggered because of what's coming through the new MPPF. I think perhaps just the final point, without getting too much into, I say, legal matters, I think there is a decorum case, Decorum and Grand Union Company, where a plan which was found not to make adequate provision for housing and things like Greenbelt Review was initially thought to be unsound, but the inspector then decided it could become sound by requiring a review to allow those things to happen. That was then challenged in the courts on the basis, well, that didn't render an unsound plan sound. It was, in the language, I think, of Mr. Christopher Katkowski, who was acting for the challenger in that case. That wasn't planning, that was a plan to plan, but that was firmly rejected by the High Court and indeed I think the Court of Appeal, and they said that that was a adequate way of dealing with the issue that was in front of the inspector. I say, not that I'm saying that you need to go down the review mechanism for the reasons I've already said, but it certainly is the case that you can, if you want to, deal with an issue like this through a review mechanism if you consider that is necessary for soundness.
Thank you. If I can bring in others, then I think it was Mr. Long first and then Mr. Beverley.
Thank you, sir. I think we just need to pause an air of caution that just because the Secretary of State has powers to do something doesn't necessarily mean that they will do it. And clearly, since the Act in 2004, given the circumstances up to date, we're in 2026, the Secretary of State hasn't empowered the council to prepare an up-to-date local plan with such veracity, and therefore to not have a review mechanism in place would be, I come back to the stability question that industries need to invest in the island. We all act here for the island's benefit. We might agree to disagree what that looks like, but stability is needed, and therefore to rely on wider powers that are out there clearly hasn't worked. It hasn't done anything about it, and therefore we must act with a highly precautionary approach that it still wouldn't happen. Also, new MPPF, new mechanisms coming in place, conscious that planning
finding the balance, it never catches up with itself. And therefore, in the permutation that the government doesn't do what it is intending to do, possibility, maybe, where does that leave us? We need some certainty in the plan, and this has been the problem up to date. We have no certainty in the plan. So it's up to you to balance those issues, to give certainty versus speed and stability. But I would say to not have a review mechanism in place, to be reliant on things that may happen or are embedded in legislation where the Secretary of State can step in is quite dangerous.
Thank you. Mr. Beverley next, please.
Thank you. Just a couple of points, if I may, and obviously, firstly, just to echo what Mr. Long has said, clearly, it doesn't fill me with particular confidence that the Secretary of State might, use powers when it's not something that I'm aware is really that commonly used. But and also, there's a legal requirement for plans to be reviewed every 5 years. That's a legal requirement, but again, going to the teeth issue, there seems to be no kind of punishment if that's not met. Our clear view is a 15-year plan period is required as a matter of soundness, and ultimately, I guess, what will be the regardless of what if a review mechanism is used, what will be the stick for the council will be the provisions of the new MPPF, which apply from, I believe it's the summer next year, which would be a 6-year plan period. I think that would spur some action, but again, going back to the matter of soundness as we sit here today, I'm not compelled that does make this plan sound.
So could I just comment very briefly, which I suspect you're aware of, the planning practice guidance on the Secretary of State's intervention powers was in fact amended in the light of the new MPPF, i.e. the December 2024 MPPF, specifically to widen the Secretary of State's freedom to intervene in plan making where she thinks fit. And secondly, again, as you will know, albeit that there hasn't been an intervention by the Secretary of State on the island, there clearly have in the last 3 to 4 years been examples of interventions by the Secretary of State in plan making in those parts of the country where he or she, I think all of the ones I can think of have been he, but he has been dissatisfied with the progress that has been made. In one can instance, I think South Oxfordshire as an instance, one can instance, I think Malden as an instance, I think one can instance Uttlesford, albeit that was slightly different powers that we use rather than powers of intervention. But clearly, the Secretary of State is prepared to be active where the Secretary of State is dissatisfied with the progress of plan making.
Thank you. Mr. Barine, please.
Thank you, sir. In terms of just coming to the last point, in terms of where the Secretary of State has intervened, that is largely to prevent local authorities from withdrawing a local plan from examination time. So we're looking at Spelthorne and South Oxfordshire areas to maintain that plan progress in order to ensure those plans are actually examined and adopted. So I think those are the points, rather than to speed up plan making process where that process is out of step with a local development scheme. So it's, I think if we were to rely on the Secretary of State to intervene where local authorities amend LDSs repeatedly in order to, then there'll be a lot of significant intervention, given that many local authorities continually and regularly update their local development schemes to suit the timescale that's coming forward. So I don't think it's an effective tool to say, oh, we'll just let the Secretary of State intervene. I think it is about ensuring those plans are there, and actually there are teeth within those plans to ensure that the local authorities move forward at an appropriate pace, rather than sort of relying on the ultimate intervention of the Secretary of State with regard to that. I think that should be there as the stopgap. There's the ultimate sanction, and I think what is important is ensuring that the local authority has those the mechanisms, not just the ultimate sanction of the Secretary of State intervening, but actually there are mechanisms in the plan making system and the planners that's there to ensure that those come forward and that housing needs are met and there is an up-to-date and sound local plan. And I think especially important where we have a transitionary, where we're transitioning from one planning policy framework into another planning policy framework to ensure that those are addressed. Thank you, sir.
Thank you. Is there any final points the council wants to make in relation to that part of the plan period? No. And noted what's been said and we'll